Thanks very much for coming along and for your patience. Just for the record, could I ask you to introduce yourself?
Yes, I'm Carolyn and I'm Chief Executive of the Legal Services Commission.
Right. Who's first up for the question? Yep. Okay, Rob.
Good to see you again. And I'm going to ask you a question I think I've asked you before in my capacity as a member of the Justice Select Committee. And I know that you're somebody who came in towards the latter end of the LSC's lifetime, shall I say. I won't make any further comment. I think we all agree that the tendering process involving the family law contracts last year was a debacle, really. And we know that the result was defeat for the LSC in the High Court. What lessons have been learned from that particular episode, and how will the new executive agency pick up the baton and make sure that that sort of scenario is not repeated?
I think it's put that in context, actually. The Legal Services Commission last year let over 5,000 contracts on both civil and crime, and the one contract which was not let was the family contract. The lessons learned, I have commissioned a report and I get external people to do that and actually look at the issues around implementation, the making of policy, consultation and then procurement. And I think it's important to inform the committee that over the course of the last 6 months we have defended 64 judicial reviews on our tendering process, of which just one was lost. And the issue on which we lost was an issue of public law, and everywhere where it is a matter of procurement law we actually won those judicial reviews. So that therefore points to the fact that when one undertakes consultation, and the process of developing policy is the point at which we really did need to strengthen our processes. We are currently out to consultation on the family tender, which we're now having to undertake because we extended the contract effectively and now have to undertake a new one. We are in the process of consultation. The discussions that we have had to date with the representative bodies, all of whom were here earlier, have been extremely positive, and the feedback that we are getting back from representative bodies on that to date is positive, even with those representative bodies accepting a reduced consultation timescale for us to undertake that work. So I think there's some key issues for me. One is how you formulate policy, two, the timescales for implementation. And an important lesson for us in the Commission is how you project manage and how you programme manages those processes, because actually the programme and project management within the Commission was not as strong as it should have been to see that through.
And that is going to be translated, you're confident, into the new arrangements if the bill...
We will have let that contract by February next year in advance of any transition to executive agency status. Following scope changes, we will need to tender the other civil contracts, save mental health, and we would anticipate doing those as the new executive agency, and obviously we'll have to take that whole process through into the Ministry of Justice. Yeah.
Thank you.
Yvonne Favard.
What percentage of positive outcomes are recorded for legally aided social welfare law cases?
I don't have that statistic with me, I'm sorry.
Could you
I can let you know,
absolutely.
Absolutely, yes, yeah.
I mean, I know you collect a tremendous amount of statistics. Could you tell us the categories of clients who will lose access to justice if social welfare law is taken out of scope?
Well, obviously those people who access social welfare law, housing, employment completely, employment advice. Could
you tell us if those specific groups are women, people with disabilities, would they be disproportionately represented?
Well, I think all of that is a matter really for the Ministry of Justice and their Equality Impact Study, which they have published as a part of the response to consultation and the original Green Paper, and that is their information which shows the equality assessment of their legislation.
But you do collect statistics of the numbers of people with disabilities, females, etc., that accesses the categories of law?
Those statistics are largely collected by providers, but we have provided what information we have to the Ministry for them to publish in their impact assessments.
So you do have that information then, because the providers do submit it to you because they have to in order to get the audit?
Well, they have to submit eligibility,
Yeah.
the eligibility of the clients that they
do
have.
to submit that as well.
Yeah, well, I will provide you with what information we're
please.
able to. No problem.
Elfyn Lewis.
You're shortly to become an executive agency of the MOJ. Do you believe this bill does in fact protect you in terms of being independent of government in your decisions to grant legal aid? And have you taken external advice on this issue? And have you consulted anybody about it?
I think the issue for consultation, again, about the abolition of the Legal Services Commission and independent decision-making is a matter for the Ministry. However, obviously, it's a matter which the Commissioners have been extremely careful to consider and indeed covered in their response to government in relation to this. I think there's two issues to raise here. Firstly, actually, the level of independence in some respects is strengthened by the bill. In Clause 4, where currently on exceptional funding cases, the Lord Chancellor can does make all the decisions around exceptional funding cases, and Clause 4 in the bill actually precludes the Lord Chancellor from making those decisions and pushes everything to the statutory office holder. Now, the issue around independence of the statutory office holder, we were very keen in discussion with the Ministry to ensure that the statutory office holder be protected from any political interference, and we were concerned about that in the first, when the Green Paper came out, and we felt comforted by the provisions in the bill around the independence of decision making. I'm very clear that it will be important for us to look at the guidance that the Lord Chancellor gives to the statutory office holder in the future about what can and can't be funded and how clear that guidance is. And secondly, I would be very keen, if I were the statutory office holder, to ensure that the independent panels of solicitors and barristers who we currently have, who actually deal with appeals against the decisions of executives within the Legal Services Commission, that those independent panels remain in place, that can give that extra level of independence and uphold or indeed overturn the decisions of the statutory office holder. So we're very keen to ensure that that independence remains in place.
Have you made any inquiries as to whether those panels will remain in place?
I have had numerous conversations with the Ministry of Justice about that, and said that that is my absolute preference going forward.
Have you had a response on it?
I think they're considering that.
Okay, again, can I appeal for brevity from both the questions and the answers, because a number of people have indicated. Michael.
My question is about the practical implications of the change from arm's length public body to executive agency. Have you had any investigations as to the potential for savings that there might be in transferring the Legal Services Commission to the MOJ? And are there any investigations also as to whether your systems and processes are actually compatible?
In terms of the savings that arise as just a move across to the Ministry of Justice, we have identified £8.5 million worth of savings which will come through effectively shared corporate services, and I've been worked very well with the Ministry of Justice about those corporate services which will need to report directly to myself as Chief Executive, and those that would need to be and therefore be somewhat more independent, and those which would be in the central core of the Ministry of Justice. So we have identified £8.5 million worth of savings, largely from staff savings arising from that. We have on top of that, there will be savings to the Ministry, but not to the Exchequer in relation to the VAT status, because at the moment the Legal Services Commission pays considerable VAT monies, believe it or not, just for another part of the MOJ to provide a service on our behalf. So that's the issue. In relation to systems, we are ensuring we have a new civil case management system which we are introducing next year, and we are ensuring that that is put on the same IT platforms, which is an Oracle Business Suite, as the MOJ's platforms. We have outsourced the production of our accounts in the course of the last year, and that is being done through Liberator, who are the same people who do the MOJ's core accounts as well. So we're doing everything we can to ensure compatibility.
Okay. So I get the strong impression that you feel this is a positive move for you and the organisation.
I see myself very few disadvantages with the move. I think my commissioners would say that they would wish to see the security of issues around the independence of decision making, and as long as that was intact, that they would not have any real issues either.
Okay. Alex Gunnell.
Witnesses have condemned the cuts to legal aid for the most vulnerable and the poor. Are such cuts the right cuts? If they're not, should they be made elsewhere? And if elsewhere, where should they be made, or where can they be made? Or do you think the cuts are so severe that they just don't serve justice?
I really think that that's a policy matter for the Ministry of Justice and not for myself. My responsibility is to administer and to implement the cuts that are decided by government, and really not to comment on the appropriateness of
So will your
that
commissioners
policy.
be able to serve justice with the budgets that they're going to have in future to operate with?
The commissioners will absolutely have a responsibility. Well, the commissioners won't exist, but the Legal Services Agency will have a responsibility to deliver what the government has requested it to do post this bill being passed one way or the other. And my responsibility as Chief Executive will to be ensure that the appropriate resources are put in the right place to ensure that that delivery is undertaken, and that is what I am doing currently.
So bear in mind what the government are asking you to do. Do you believe that this cuts will, with the cuts, having had the cuts imposed, will you be able to deliver that as you say?
I see no reason at the moment, particularly if you take a whole area of legal aid out of scope, that just reduces the amount of work that the Legal Services Commission has to do.
But you're not going to say whether it's right or wrong?
It's not my role to say whether it's right or wrong.
Okay. Andy Slaughter.
Yes, well, related points. I was just having a look at your submission to the in response to the Green Paper advice, and it's the annex to that which does raise the sort of practical issues and concerns you had. It's admirably brief, but I'd like to ask you to amplify one or two of those points. You say under provider sustainability, we have concerns that fee cuts may result in market failure and premature exits from the market, where, for example, a firm or not-for-profit organisation becomes insolvent. Do you think that is, from your knowledge of the market, that's a serious concern? And as well as the fee cuts, will that also be affected by the scope changes?
I think the issue around market sustainability is not one issue or the other, and actually on civil it's about the single gateway as well, and it's the impact of the three different budget reductions in relation to the single gateway, the fee reductions, and indeed the changes in scope. And I think the area where we have had some concerns about large reductions in scope and the ability of certain parts of the legal services market to adapt to that, particularly where the not-for-profit sector, which the government absolutely accept in their impact assessments, and in the immigration and asylum field.
You anticipate my next question, because you also say on viability for not-for-profit, we've noted that these may be particularly threatened by the changes proposed, as these will coincide with funding reductions being made elsewhere. And we believe the government should look at the funding of not-for-profit organisations collectively by the public sector to ensure that these valuable advice agencies are maintained at an appropriate level. Have you had any response from the government as yet that they will be considering that?
Yes, I think that is being positively dealt with by the Ministry of Justice, and the Cabinet Office have said that they will undertake a review to look at the wider impacts of advice across the sector, and the wider advice rather than legal work, more general advice across the piece.
The problem is that we have immediate, already, before the bill goes through, we have local authority cuts. I could think that law centres in West London, where I represent Paddington Law Centre, could close tomorrow. And you obviously do have a clear concern that this is an important part of the provider market that is going. Are you able to put any greater sense of urgency into this? Because there may not be much to to support by the time reviews have been done?
That area of work in terms of taking forward policy in relation to the advised sector more widely is definitely, again, a matter for the Ministry, and indeed I think the Cabinet Office are taking the lead on that. I think it might just be helpful to you for me to just give you some statistics. At the moment, on civil, whether it's not-for-profit or solicitors, we have 3,370 providers. On crime, we have 2,000 providers. Last year, 6% left the civil market, of which 0.6% quoted their reason for leaving reform to the legal aid system. On crime, actually, the figure was higher. It was 9% left the market, 1% quoted a legal aid reform as the reason. So I just think the point that I want to make is that it's a lot of providers that we have.
Yes, but changes...
Just remind you, Andy, that your colleague is waiting to ask the question as well.
Changes are happening this year, not last year, and next year as well. And you also say that the experience of recent years has shown that working to unrealistic timescales has increased risks resulting in poorer outcomes, as well as putting those most closely involved under considerable pressure. And you note that a rushed implementation may have to be halted, for example, if there's a successful JR. Are you not concerned at the speed with which these changes are going through?
I think we have had considerable discussions with the Ministry about the speed of the change and the implementation, and continue to do so. And where I have raised concerns, in fact, the family tenders, we have extended the timescale on that. We will not be implementing new family contracts in November, but in February, because the Ministry have taken on board the concerns that we had about the speed of that implementation and therefore the potential success of judicial review if we did it one way or another. So I am satisfied that the conversations that we're having with the Ministry, where we are raising real risks to implementation, that those are being taken on board.
Okay, Green.
Thank you. I'm also interested in just learning some lessons from your experience of managing the market. And as you will know, in the past, people have presented with clusters of problems in different categories of social welfare law. Clearly, as we strip most categories out of the ambit of legal aid, the possibility of dealing with those groups of problems will be removed. When you say in the past a very small percentage of providers have left the market as a result of legal aid changes, what's your view on the likely scale of departure from the market when whole categories of social welfare law are removed, and therefore the capacity for the remaining providers to deal holistically with people's problems?
I do think there will be impact on the not-for-profit sector, particularly in social welfare law, without a doubt, and their ability to adapt to a contracting environment and fixed fee regimes. I do think that is a risk. I do feel, however, that we will have sufficient providers to be able to give a service. You will be aware of the going into administration of Immigration Advisory Service last week. I was concerned about coverage issues in relation to the Immigration Advisory Service, and I have been in discussion with the administrators over the last few days, and I have to say we have a huge number of people contacting us who are prepared to take on that work. So there is an immediate example of something where I was very concerned about whether we would be able to get coverage in non-urban areas in particular, and actually it would appear that the contact that we are getting from external providers is that they would be prepared to take on that work.
And do you think when whole categories of law can no longer be covered, and therefore there will be dividing lines where legal advice can or cannot be provided in a single case or with a single client, that is the most cost-effective and best value way in which to support that client, looking at cost to the public person around?
The Legal Services Commission last year, as you know, very much tried to group as many of its contracts and categories of law together on the basis that an overwhelming number of clients do present with a multiplicity of issues, and that was how we undertook our contracting last year. The family contracts that we are actually undertaking now, we are not insisting that people do private and public family law. we are allowing people to do either one or the other, obviously because of the impending changes.
Order. We have now, unfortunately, run out of time. The committee will meet again to take further evidence at 9 a.m. on Thursday. I now call the whip to move that further consideration of the bill be now adjourned. The question is that further consideration of the bill be now adjourned. As many of that opinion say aye. Aye. Any opinion no? I think the ayes have it. The ayes have it. Thank you.